I'm Elizabeth Lon. I'm an immigration lawyer at LM Law Group. And today I have George Hamzo from Lerners here. George is an employment lawyer with Lerners. When we're talking about businesses bringing employees to Canada, oftentimes there's an assumption that, well, we'll just use the same employment contract that we did in the US with the same employees. Are there any issues with them doing this?
The first thing you should know if you're a US company hiring workers to work in Ontario is that the concept in the US called at-will employment, it just doesn't exist here. It's sort of in Ontario. So for Ontario employees, they're presumptively entitled to what's called reasonable notice upon termination. And it's determined by a number of factors, probably the most important of which is your tenure and sort of level of responsibility you have within the company. This sort of liability can be quite onerous, and if you're not used to it, it can be quite shocking to you. Something to sort of think about is to be aware of that if you're coming into this jurisdiction, and there are a lot of great reasons to do so. It's something that you should be sort of budgeting for ahead of time as part of your workforce costs. So just to give you an example, reasonable notice can get as high as 24 months pay. And there are now some decisions in Ontario that go even higher than that.
Yeah, and I think it's a lot of it is planning and having that contract that protects your rights before you get started.